I'm Barbara Stewart. I'm a real estate attorney here in Greensboro. Been practicing real estate probably close to 15 years and do almost exclusively residential closings at this point.
Okay, wonderful. Thank you so much for joining us today and helping us learn a little bit more about real estate and sale of residential properties. So could you explain to me the difference between, the students have looked at what escrow is, the escrow period. Now, what is the difference between an escrow state versus an attorney state?
Well, for me, now, first of all, I'm going to preface it by saying I have only ever practiced real estate law in North Carolina. So I have always been in an attorney state rather than an escrow state. To me, the major difference is that in North Carolina, attorneys work with title companies. We do our searches, we send opinions to the title companies, they issue title commitments based on that. But we do all of the searching, we do the interactions with the lenders, we conduct the closings, we distribute the money and do the final opinions, and then the title companies, based on my opinion, will issue a title policy. So that's,
sorry about that. Escrow process. During the escrow period, are you the one who receives the earnest money from the buyer and you hold that in a trust account like an escrow company would?
Sometimes yes, and sometimes no. If they ask us to hold the earnest money, we will hold the earnest money and we keep it in our trust account and then use it at closing, or if it doesn't close, distribute it the way that it's supposed to be distributed. But sometimes the realtors will have an escrow account with their realty company and they'll hold the escrow money instead of the earnest money.
That's very interesting. So that's interesting. I've only ever worked as a real estate attorney in escrow states. So in Nevada and California, we use a third party called an escrow company, and that escrow company is who receives what we call the escrow money or the earnest money. It goes in there. They also are the ones that take care of the closing and making sure all of the contingencies and everything has been that needs to take place for the closing has taken place. So very interesting. And I think so when I practiced, I did title searches and I did assist title companies, but only in commercial, large commercial deals. So the title companies had their own attorneys in-house that kind of dealt with. So very interesting. Okay, so let's say you get a new client for a residential real estate purchase. Walk me through kind of your process.
Okay, so most of the time, the way that it works is we'll be contacted by a realtor that we work with. But they'll send us a contract and it'll be an executed contract when we get it.
So it's a purchase agreement or a real estate.
An offer to purchase. And there is a standard form in North Carolina, and the realtors in this state, the realtors are not allowed to alter that form other than filling in blanks and so on. So they can't draft clauses and they can't do anything like that. That's restricted to an attorney. So during the process, sometimes I get a request to do that too. But once we get that contract, then I actually don't do my own title searches for the most part because I work with an incredible title searcher. She operates here in Greensboro and actually used to work with me at a law firm, but she has her own business now. She is hands down the best I have ever seen. And so I trust her more than me. Excuse me?
I don't know what is going on. Yeah, sorry about that. What is a title search?
Okay, so what she's going to do when I send her the contract, she's going to see the property address. She's going to see the names on the contract. She's going to start looking, and the very first thing she's going to do is check to see if we can find a title policy that was issued on this property before. So in other words, I'm looking at one right now sitting on my desk here, and we are coming up from a policy that was issued in 2017. Now, sometimes we'll do that. We had one today that she's taking back with her because although there's a title policy from 2018, frankly, I don't trust the attorney. So like that.
Title policy.
Title policy, this is title insurance. So that's kind of the end result of what we do, is that I'm going to do my process. I'm going to search. I'm going to make sure things are done properly. I'm going to make sure that there aren't any problems with the title, that we conduct the closing correctly, and that we finish up correctly, so that the title company will issue title insurance to lender and to buyer if there is a lender. Title insurance is mandatory for loans. That's, at least the lenders make it mandatory, but owner coverage is not mandatory in North Carolina. The owners can choose it or not choose it, except in my office where they have to say yes. Because and when they don't, I tell them what I call the Barker Baker story, to just show them what can go wrong, and there's nobody that you can go after for it. So this was an experience for me. I actually had a closing and we missed a deed of trust because the Register of Deeds indexed it under Baker instead of Barker. No way we would have found it. And you can't sue the government. So title insurance stepped in, they paid off the mortgage, and then they went after the seller. So that's what it's insurance. It insures you against problems with the ownership before you were the owner, is how I explain it.
Fascinating. Okay, so that situation, the Baker Barker story, is that an issue with the chain of title?
Well, it is, in that as you go through the chain of title, you're looking at what we call ins and outs, where one property passes from one person to another, and we need to make sure that it was passed properly. But to me, along with that, you're looking to make sure that as it got passed from one person to another, it passed free of liens. And so loans that are outstanding, judgments that are outstanding, all of those things to me are part of the title search, and all have to be accounted for, some in interesting ways. And today was a great example of that. We had to put a closing on hold for a week. Why did we have to put it on hold? Because there was a judgment against the seller. It was docketed May 5th of 2010, which meant it died May 5th of 2020, unless it was renewed. So today I went in, it was not renewed, and we're able to go forward now because now that judgment no longer attaches to the property.
Wow.
So it's all of that kind of stuff.
And how did you uncover that judgment?
Excuse me? How did I find it?
Yeah.
Okay, again, like I said, my title searcher collects all the information, but I also do some of the title searches myself. And for the judgment, there is a judgment index, and you can actually go down to the courthouse and use their computers and search for judgments there. But if you're like me and you record deeds and deeds of trust electronically, you've bought a subscription to that. And so I can search it from my office. So we find judgments, we look for special proceedings, HOA liens, for example, all that type of thing.
All right, thank you. So we've been talking about sellers' duties to disclose, and I'm curious, in North Carolina, what is the rule for the seller's duty to disclose?
Well, I guess what I'm wondering is disclose what specifically? Are they supposed to disclose if they have knowledge that they have judgments or they have an issue or something? Because the truth is, most of the time they don't know. And it always fascinates me that these judgments, for example, don't show up on credit reports. They don't show up in, so I can't tell you how many times I've gone back to somebody and said, there's a judgment against you that was docketed on such and such a date with this company. And they'll say, I don't have any judgments. And then they start to look. And then they admit, yes, there was one, they just didn't know it. 99.9% of the time, that's what it is. As far as disclosures are concerned, I'm not going to trust anybody to do that. I'm going to look myself because they may not know or they may not tell. And as far as duties to disclose, I don't even want to get there. I want to find out for myself.
That makes sense. So, so you've done the title search and everything looks good, that all the judgments have been cleared. Maybe you find some easements, some right-of-ways. So you'll note them, I'm assuming, and then what is the next step after that? What do you do after you do the title search? So
the next step with easements and rights-of-way and so on, we're going to point out anything that comes up in the title search. Most of the time, those types of things in the subdivisions that are done are on the plat map. They're not going to be recorded separately.
Oh, that's very interesting.
Yeah. So where you run into the more separate stuff is out in rural areas. This week, I did a private road maintenance agreement. And that's the kind of thing, I would not expect that to be an issue within Greensboro, but it doesn't surprise me that it's an issue in Liberty, for example.
Very interesting. Okay.
Yeah. So
we talked about private conditions versus public conditions and how courts may treat those differently. How did you discover the private condition?
Well, when I'm searching, and I don't know that it would necessarily be a private condition because the plat map is recorded.
Oh, okay.
And easements would be recorded if they're done separately. The private road maintenance, there was actually one recorded. The problem was that it was a commitment only to an old developer. So it no longer was effective, and so we had to come up with a new one. But that's generally looking at the plat, looking in the records. If it's not in there, we're not going to find it unless they disclose it. And that's where a lot of things come up. And I think it's more that people don't know what is usually disclosed and what isn't. So fortunately for me, I haven't had too much of this, but I've heard stories of people saying, well, you never told me that the sun rose on this side of the house, for example. Well, that's not part of what we do. But it really comes down to the age of the property, how it's passed. When it passes through an estate, that can be particularly crazy. When you have a property.
Tell me a little bit about how that differs. What happens when something passes through an estate and how?
Okay.
Estate. I don't know that my students know what an estate is actually.
Okay, so this when somebody passes away, then you have to deal with their assets and take care of certain obligations and so on. And I will preface by saying I do not do estates work. I have a great recommendation who's an Elon graduate that I send all of that to. But as far as estates are concerned, what we have to do is we have to look in there and make sure that certain things have been done so that they're far enough along in the process to be able to sell the property. And you would be amazed at how often we refer to it as the mama's not cold yet and we're selling her house syndrome.
Oh gosh.
So because they'll come in and they'll just say, we've got a contract on the house, and they'll say, so did you publish to creditors? What? Mm-hmm. Well, that's one of the prerequisites. It has to happen. And the title companies are getting a little looser on that, but they still want to see that. So the property is going to pass. Big first question is, did they open an estate? If not, they'll need to do that. Second, was there a will that dictates how the property is to be divided? Because if not, then we have to look at the intestacy statutes and see who gets what and so on. And with the states, I don't know, there's a lot of things that come up that can be confusing on those. One of the interesting things and very misunderstood things in North Carolina is that in many states, the way that they establish the chain of title after somebody dies is they do what's called an executor's deed. So the executor of the estate actually deeds the property to the heirs. We don't do that here. Yeah. In North Carolina, the will acts as the deed. I know it's a weird thing. People just don't get it. I can't tell you how many times I've seen an executor's will recorded. It's not necessary and it's not useful.
Yeah, that's so interesting. There's a lot of unique North Carolina property laws that I think. Oh, yeah. So one of them that I have been telling students about is that we are a race to the court jurisdiction. So what does that mean? So let's say the title search looks good and we're moving. We set the closing date, right? I guess let's talk a little bit about what happens at closing and then what it means that North Carolina is a race to record.
Okay, so I'm sitting on one right now, for example, and I'm going to use that one. Right now I'm doing Zoom closings. So this young man and I sat down via Zoom. Now we don't look at documents on the screen because there are privacy issues and so on. But we go through everything. As of yesterday, I can now watch him sign remotely as a notary. That's a brand new thing for North Carolina. And so then he came over here, brought me the documents. So now I have, in the meantime, I've gotten the seller to sign their part. So I have the deed. I have the deed of trust. But before I can do anything, first of all, I have to have lender approval. And what we're waiting on right now is lender money. But before I go to record, I go back to the Register of Deeds or in whatever county it's in, and I check to make sure that since we did our title search, nothing has changed. Nobody has filed a new deed of trust. On one, I discovered a UCC that had been put on the day before. So we check as close as we can to the actual time period. And we do the same thing with judgments. That's one reason why we have the subscription that we have. Because as soon as we finish up verifying, we put those documents on to record. When they say race state, that's what it means. Race to the courthouse and whoever is first wins.
So gosh, this microphone. I have to figure out what is going on here. So that's so fascinating that so essentially you do your title search. I don't know that students know what the difference is between a deed and a deed of trust. So I guess we should explain that to them.
Okay, because that's another North Carolina thing.
Yes.
And I tell my clients this, in almost every state, a deed of trust is called a mortgage. And that's what it is. It's a mortgage. We have a different name for it because of the way that foreclosure happens here, that it happens through the clerk of court rather than in a courtroom. And so the process is different, but I will tell you that I have now looked at a standard deed of trust that I've gotten from a lender, and I've compared it to one from a state that has mortgages. 99.9% of the document is exactly the same. So that's what it is.
I agree. I've worked in deed of trust states, but both Nevada and California, interestingly enough. But we did have a transaction out of state that we looked at the mortgage and we're like, this is pretty much the same.
Yeah, it is. It's just the process that differs. But anyway, because we are a race state, the very last person that gets there is the last person. So if, for example, with this UCC that I found when I was updating, which is why we have to update. We don't have what's called gap coverage here that a lot of states use, saying that the period that we have the seller sign something saying the period from the title search until the deed is recorded, they are, basically providing gap coverage for that. North Carolina doesn't do that. Interestingly enough, with the COVID world now, there is a little bit of an exception to that, because for people who do not record electronically, there are many counties in this state right now that are not open, the Register of Deeds office. So you take your documents, you stick them in a little lockbox, and they get to them when they get to them.
Wow. So when the buyer get the keys, right, and get the title.
Yeah, and that's another big question, because that's a seller option. I've had sellers who have handed them the keys before they ever walked into the closing room. I've had others that want it to be recorded. The one thing I can't do, and this is the thing that drives everybody crazy, is nobody gets a penny of money until we're recorded. And as I tell them, that includes me. And I'm the last person who gets paid out of everything. But the realtors will often not understand why they can't have their checks at the closing table so that they don't have to come back.
Right. So in non-race states, so I've worked in both non-race jurisdictions. At the table, when the escrow company's there and we're closing, sign the deed gets signed over, I get my keys, the realtor gets her check, the seller gets their check, and or their wire transfer, because they also do wire transfers with us, which they don't do.
That's another thing we don't do.
So here there is an option where sellers can still give keys, even though
that is strictly up to sellers.
So does the buyer have the right to occupy? I guess they get a license to enter the place then, pretty much, until.
Truthfully, nobody gets to do anything until that deed goes on record, unless the parties agree otherwise. So buyer's not allowed to go in, seller's not allowed to get money, nobody does anything, but we do it quickly, because we're going to do the one that I'm sitting waiting on right now. I did this closing at 11 o'clock this morning. Right after I got funding approval, which is approval from the lender, I updated. And then we waited for the wire to come in, and we're still waiting for the wire to come in. But as soon as that does, and I'll update one more time because of the length of time that's gone by, then we're going to hit the button and send it to record. And as soon as it goes on record, we call everybody and tell them. But it's at that point that the buyer owns the property, and it's at that point that the seller owns the money, and the realtors and so on. So it's just a very different way here. We don't have a space between the closing and the actual recording. And that surprises a lot of people. I'll tell them the process so they'll understand, and they'll say, oh, so when will that happen? And I said, well, probably within about 3 hours. And they look at me and say, oh, I thought it would be a week. Well, we don't do things that way here, because again, since we're a race state, a lot of stuff can happen.
Right. Have you ever one, which you
but I can give you a better one than that. This dates back to 2008, slightly before 2008. And for the real estate world, the world is divided into pre-2008, post-2008. Okay, so pre-2008, I was working in a law firm, and we represented a number of big builders who were going under one after another. And so we would get down, I used to go over to Winston-Salem to do closings there for one of our builders. And we weren't recording electronically there. So it got so bad with mechanics liens and things like that, that I would go to the courthouse, I would search their books, I would search the secretary's desks to make sure that there wasn't anything there. I'd go do my closing. I would come back to the courthouse, check the desks, check the books, ask if any temp stuff was out there, and then I would run like, over to the Register of Deeds to put my stuff on record. And even with that, one time, a mechanics lien got on first.
Wow, that is so stressful. And there's no time in the legislature to change, to make it so that they're not. So just to kind of give an example to the students. So in Nevada, for example, or in California, it is based on not when the deed is recorded, but when it's executed. So if, for example, the deed is executed and there's a lag between when it got signed and when it gets recorded, then it doesn't allow for somebody with a lien against the seller's property, against the seller, to attach it while we're waiting for the executed document to be recorded, right?
And we're just the opposite. It does not matter what date is on that deed. And in fact, if you look in the Register of Deeds website and look at deeds, probably about 10% of them don't have a date on them. They just forgot to fill it in, because the only thing that matters here is the recording date. So anything that happens before the recording, if it happens 5 minutes before the recording, it's first. And to me, that actually makes more sense, because how do those lien holders out there know that a deed was executed?
I understand that. It does make sense, right? Because it doesn't, if it's not recorded, then how do people know that the deed exists, right? You could have,
Exactly.
You could have a seller who has already deeded the property to a brother or sister who has not filed the deed or recorded the deed, and then tries to again sell to another, sell to a buyer.
Exactly. I like our method. I really do. It's a little hair raising sometimes, but to me, in the long run, I'm more satisfied that I found everything I need to find.
I get it. So there's more, and that makes a lot of sense. You're more reassured that things are going to be recorded, because if they're not recorded, people are going to record them, right? That's fascinating. Well, thank you so much. That was so very helpful. I really appreciate it. I'm sure the students appreciate me not just talking at the screen to them. So
I'm happy to do it.
thank you so much.
You're very welcome.